Hi everyone, thank you for joining our webinar today. We're so excited to have you here with us, and today I'm so thankful to David Young, who's joining us from David Young Law, to talk to us about CASL and what your charity or nonprofit needs to do before July 1st. So as we approach that July 1st deadline, I can tell that CASL is a very hot topic because we have 2,000 people registered for this webinar today. That is just really huge. So thank you all again for joining us. My name is Cindy Unin, and I'm the Charity Marketing Manager at Canada Helps. For those of you who are new to Canada Helps is a charity helping charities. We provide charities with open access to our affordable online fundraising program and training so they can better connect with the people who support them. And for donors, we offer a one-stop shop for donating and fundraising for any registered Canadian charity online. Since 2000, over 1 million Canadians have donated through Canada Helps, and together we've raised over $700 million in donations.
Hello everyone, thank you Cindy. It's a great pleasure to present this webinar today, and certainly to participate with Canada Helps in this very important really regulatory activity that's going on coming up to July 1 in connection with our national anti-spam law. As Cindy mentioned, my name is David Young. I am principal at a regulatory and privacy counsel practice firm in Toronto, David Young Law. It's a national practice, is a national practice that focuses on regulatory compliance for all organizations, both nonprofit, charitable, and for-profit. And I've certainly had a lot to do over the last 3 years since CASL came into force with advising charities and not-for-profits. So what I want to do today is there's a number of items to cover. The highlight obviously is what you need to do before July 1st, and there's some interesting developments. You may or may not have read about them, but as of yesterday, one of the events that was going to take place on July 1st has been suspended. That is the private right of action, which I'm sure many of you have heard about and probably been quite concerned about. And I will tell you, still talk to you about the private right of action and how that suspension is working. What I want to do, though, before I get to the private right of action and really to set up the July 1st date, is to go over some of the basics about the basics of CASL, who it applies to, what are its key provisions, and what are the implications of those provisions to charities and not-for-profits. And I hope that one of the results of this webinar, and I'm not presuming that you may or may not have come to this understanding before, and you may have, but really the Act has many implications, many provisions that do apply to charities, and I'll try to highlight those. It's very important for you to understand those as you go forward and aim for what I guess everybody hopes is a compliant status under the law. I will highlight what is happening on July 1st. It's important, notwithstanding this news out of Ottawa yesterday, it's still an important date, and I will indicate the implications of that going forward. So let's move now to some of these sort of basics about charities, CASL, and who it applies to. And you can see from this slide that it's actually a global, all-encompassing rule. It applies or prohibits the unsolicited, and in some instances applies to misleading or fraudulent commercial electronic messages, as well as certain other online activities by any person in Canada, including charities and not-for-profits. I can tell you, in the run-up to CASL coming into force, I can't remember the exact timing, but there was a wide belief that it wasn't going to apply to charities. Even the government, many of the government people involved were really saying that to anybody who asked, but on closer examination, and luckily this examination occurred before the law came into force, it was realized it does apply to both profit and non-profit businesses and charities, and as a result there were a number of representations made by probably stakeholders you know of, Imagine Canada, Ontario Nonprofit Network, that interfaced with the government and made sure that, and there were changes made at that time to make sure that there was more scope for charities and not-for-profits to more either be accepted or exempted from the law, or at least or for it not to apply at all. So the law is this, what we characterize as a ban all but make exceptions approach. And that's the problem with it, really, for anybody like yourselves who are saying, well, how do I figure out what to do with this? And unfortunately, that's the nature of the law. It didn't narrow it down to just bad spam or bad email. That's what's prohibited. It banned everything. So this is what we've got. It's a law with significant financial penalties. And those financial liabilities can extend to directors and officers of the organizations governed by the law. So that's the broad application. Really the other, I guess we'd call it key criteria or indicia of who it applies to or how it applies is, as I mentioned, it applies to commercial electronic messages that are unsolicited. So that, you know, in its broad sense could be called spam, but really there's lots of commercial electronic messages that everybody in the world and in our world believes are not really spam, but are governed by CASL. And this is really the, I guess, the next key item that, and again, I'm sure most of you on this webinar today are aware of that it will apply to charities, not-for-profits who send commercial electronic messages, and those messages are such that term is defined as any electronic message that would reasonably be determined to have as a purpose encouraging participation in a commercial activity. And a commercial activity is a very broad definition. It's any commercial transaction, whether or not for profit. So you purchase something from an organization, a vendor, to supplies for your organization. You sell a product, even if the ultimate benefit of selling that product is for the charitable purpose. That is covered. That is included in a commercial transaction, and that's why the law applies to charities and not-for-profits. CEMs, as the acronym we refer to them, include all sorts of electronic communications with the one specific touchstone that they must be sent to an electronic address, and so it's understood that social media postings, unless they're addressed to a specific person or address, unless a social media posting or a website posting is directed at an individual or an address, it is not caught by the law. But otherwise, any social media directed at an individual would be governed by the law. So what is happening on July 1st, the $64,000 question? The most important event that's happening on July 1st is that the transition period for implied consents is ending. And I'm going to talk about this more, but it really is making much more rigorous the compliance requirements for what we call implied consents under under CASL, and I'm going to talk about that also because that has significant application to charities and not-for-profits. There was to be come into force on July 1st this private right of action, which had potentially significant added risk for senders of CEMs, including charities and not-for-profits, that may be non-compliant. And as I'm sure many of you have are aware of that, I will talk also about that today. But as I mentioned, in fact, the effectiveness or the in-force effectiveness of that has been suspended by the federal government as of yesterday, pending further review. So it's not as significant as an issue, but what these two expected events, and really what we can look to is a 3-year sort of breaking in period, if we call it that, for CASL, is coming to an end on July 1st. So the CRTC has been enforcing the act with enforcement actions. They've been investigating issues that are complaints that have come to their attention, and they are expecting that with 3 years under their belt and under organizations' belts, that they will have had sufficient experience to know what they need to do to be compliant. Well, the fact is, and there have been, I think, and you'll probably see news of surveys that are coming out. I understand that Imagine Canada and ONN are publishing one shortly, and there's been another one that I'm aware of in the commercial area that, or the business organizations, among business organizations, that show that there is still a significant lack of understanding of what CASL's requirements are and how CASL compliance, full compliance, should be achieved. And so it's like, it's not, we would say, well, okay, that's the status today. I guess if this private right of action were coming into force on July 1, everybody would be a little more nervous if they don't understand what the requirements are and are unclear as to whether they meet the full compliance. But what delay of that provision does, I think, is quite usefully enable everyone, and I'm not pointing the finger at any particular group of organizations. I think small businesses are certainly in a category where they are in a sort of more of a gray area in terms of full compliance, and potentially charities and not-for-profits, because they don't have the big infrastructure that large organizations do to set up all the compliance rules. But it enables all stakeholders to really revisit and refocus on compliance requirements. And I'm going to end up with discussing what I call a CASL compliance program, and really a checklist of what should go into that program, and hopefully that'll be useful for a takeaway from this webinar. So moving to broadly issues for charities and not-for-profits, and I know that probably everyone, or almost everyone on the line, represent charities, but I know many of you also have not-for-profits that are related to your work. Sometimes you bifurcate your activities, and really charities are a subset of the rules that potentially apply to not-for-profits. So the first issue is, do you send commercial electronic messages? And the question in answering that, or what you need to ask to answer that question, is at least one of the purposes of the message you're looking at promotion of a commercial activity. Secondarily, is the main purpose of that message fundraising? Fundraising has a special exempt status under the exemption provisions of CASL. if the main purpose of a message is fundraising, then that message would be excluded from all of the key requirements under CASL. But and we'll see that there's some gradation as to whether a fundraising message may be still a CEM. There's definitely a scope for an issue there. So all organizations, and I'm obviously we're talking about charities and not-for-profits, need to look then at really the two other categories of let's say called facilitating avenues under CASL to enable compliance. And the big one, a very big one, is implied consent. And consent is really one of the two basic rules in the law. And I'll come to that in a minute. But the law is a consent-based law, and so either there must be express consent or implied consent for a CEM governed by the law to be sent. And so you're looking for consent, and the question is, do you qualify, or does the CEM, the message in question, qualify for implied consent? Secondly, you would look, does it qualify under a specific exception? Because again, that would enable compliance without either the consent requirement having to be met or some of the other requirements. So moving to the key requirements under CASL, there are really two key requirements, and I'm just putting these out because really I'm sure most of you are aware of these, but they're important to understand when you start looking at these exceptions and implied consent rules. So the key, number one key, is what we call the content requirements, which stipulate that basically sender contact information, specified sender contact information, must be included in an email in a CEM governed by the legislation. And secondly, an unsubscribe mechanism must be included. So globally, that's the first key requirement. The second is the consent requirement that I just mentioned, and that consent must be, or may be, let's call it, may be either express or implied. And as I mentioned a minute ago, implied consent is a very important category for all organizations to look at. And as I mentioned earlier, there are certain exceptions, and I want to turn to those now, but just highlight again that the law running afoul or offside of these requirements exposes organizations to significant potential penalties. So this is sort of the next slide is an outline of what we call sender contact information, identity of the sender, and mailing address and one of either a telephone number with active response voicemail, an email address, or a web address. And if it's not practicable to include that in the message, it can be effected by way of a link to a readily accessible web page. The second content element is the unsubscribe, which must enable a recipient to request removal from the list that the email has been sent from, and must be able to be readily performed. And won't go through the other items, but those are some stipulations that need to apply to the unsubscribes. So what we recommend is that to ensure those content requirements are met, that organizations develop what we call a CEM template, and it has all of that information. It's basically their template for sending emails. It's not a requirement of the Act, but we recommend that as a best practice, and we also recommend that it be used for all CEMs, even ones that you might consider or might determine either are exempt or subject to one or other of the, let's say, an implied consent or other facilitating requirement under the Act that so strictly doesn't require all of that content information. The safest way is to basically develop this template and use it for all communications going out to stakeholders. Let's put it that way. So to run through the exemptions, and this category, there's two main categories of exemptions under the Act. The first is from what I call all CEM requirements. So that is the consent, contact, and unsubscribe requirements. So the consent and the content requirements. And this is the list that is spelled out in the legislation. The two that are most relevant or very relevant to charities is the one that I've mentioned for CEMs that have primary purpose fundraising, and that's a very important exemption. But another exemption that is also very important is in a sort of a colloquial way, it's called the business-to-business exemption. But in fact, the legislation reads organization to organization that have relationships between them. And so that's very broad. It's not defined, and I don't want to, I mean, I'm certainly prepared to respond if anybody has questions of what a relationship may mean, but it's really an organization with whom you've had contact and have some sort of ongoing connection with, and it must involve the activities of the organization to whom the email is being sent. So those are the two most important, what I call exemptions from all CEM requirements. Exemptions or exceptions to the consent requirement are really not, so they're really commercially oriented, I would say, not to say these couldn't apply to a charity or not-for-profit, but none of these are really categories that I would see your organizations typically making the subject of an email communication, and this is the more limited exception, which is the consent requirement. More importantly, is to understand the rules for implied consent, and you can consider these really exceptions to the the express consent requirement, and what they do is articulate rules for where, as I called it, as I mentioned it, and it is called in the legislation, implied consent. But understand, and this is quite unusual, this piece of legislation, the term implied consent is exhaustively defined. I use that term because it's specifically defined in the legislation, and it's really two broad categories of relationship, which are the existing business relationship and the existing non-business relationship. There's also another category, which is this language that I've put just in the subtext underneath, where an organization, a potential recipient, has published their email on a web or publicly and without indicating that they don't want to receive emails. Well, you can send to them. That's implied consent. But more important for charities and not-for-profits are these two defined existing business or existing non-business relationships. And I don't want to underplay either of them because with respect to your organizations, because an existing business relationship is, this is a sort of summary of what it is defined as. It's a commercial relationship not more than 2 years old, or in the case of an inquiry to an organization, one that has been made within the last 6 months. So commercial relationship is anything contractual, but it is actually anything selling a product. And that can include a ticket to an event. It can include selling an item of merchandise. That establishes an existing business relationship, which then qualifies for this implied consent. And it, as it said on the slide, it must be less than 2 years old. It must have occurred at no earlier than 2 years previously. The other category, also very important for charities and not-for-profits, is this existing non-business relationship. And So very important, really for charities are the first two sub-items in this definition. A donation or gift made by the recipient within the previous 2 years to a registered charity, that's a charity registered under the Income Tax Act, or volunteer work or attendance at a meeting of that charity, again within the previous 2 years. So those are very important, obviously, and you will look at your databases and determine who of your stakeholders, potential email recipients, qualify under those two implied consent, categories or qualifications for this existing non-business relationship. The other possible category applies to non-profit organizations, which is actually defined as in the Income Tax Act, not-for-profit entity, and it is membership, basically membership in the non-profit organization. That is not charity. That's this different kettle of fish, or different entity, a not-for-profit organization. So those two implied consent rules, I say really the implied consent rule with those two very important definitions feed into this end of the transitional rule coming up for July 1st. And what we're going to do is ask you, I think, do you type this in as a poll? We're going to ask for a poll on this. Okay, so we're going to ask you, I'm going to put a question, and as I talk about this, you can just launch it because you've got it already set. Okay, so we're actually launching a poll and asking you to respond to this poll. It really is how many organizations are aware of this end of this transition rule and have reviewed their status with respect to it, and that's really the key item I'd like to know, or we'd like to know. But what really is sort of coming out of that is, well, what are you doing about it? And let me just explain the rule. Do you need to do anything else, Cindy? So the rule is it's sort of an interesting qualification of the two subcategories of the non-business and non-business existing relationship rules. And as you saw a minute ago, I mentioned they are subject to a 2-year, 6-month limitation period, depending what the basis for the relationship is. They are, and those are the general rules. But until July 1st, if any of those relationships existed, going back in time without reference to the 2 years, existed as of July 1st, 2014, then they also qualified. So really it said the 2-year rule didn't apply. And that was very significant for many organizations because they didn't really have to pay a lot of attention to when they last heard from somebody or last communicated with somebody. And but that rule is ending on July 1st, and the flexibility of that rule will then be lost, and a much more rigorous, really, record keeping will be required. And what we're saying is that, and this is really the purpose of the poll, is that those of you who either knowingly or unknowingly have relied on this transition rule right now and really until July 1st, using it in effect until July 1st, must look at and really determine a strategy for compliance, recognizing that the rule will no longer apply. And the compliance really is confirm that you have, there's really 3 options to that compliance, and I've got it set out in another slide, but I'll just mention it here. It's number 1, confirm that a recipient qualifies under one of the general implied consent categories that I've just mentioned on the previous slides. Number two, also very important, and I suggest organizations have 3 weeks to do this, and it really is 3 weeks really to initiate it, but to if you haven't got express consent from the recipient, to reach out now and seek that express consent. And you can do that right up until June 30th with as many emails, as many communications. So you're allowed to communicate, because you're relying on this transition rule, right up to that date. It doesn't, the express consent does not have to be received prior to July 1st. You can make that reach out, as we call it, consent capturing strategy, initiate that now. The third option would really be, it would really be, okay, we don't have any other basis to send to this category of recipient. We may, on a sort of ad hoc basis going forward, qualify them under one exemption or another, but until we have that either qualification or we are able to qualify them under a consent rule, stop sending to them. So that's really option number 3. So I'm going to talk about the 2 next slides I want to talk about are, first of all, now let's move, regulatory penalties. So really, and this is more important, this slide is more important today than it was yesterday, because this is really the financial liability exposure under CASL that exists today. If we'd had the private right of action, I mean, maybe cynically I would say, well, maybe the regulator is actually going to allow the private right of action to do some of the regulation, but that's not going to happen. So I think, and we've had a lot of experience with what we call administrative monetary penalties. There have been half a dozen or more actually imposed over the last 3 years, and they've ranged so far between a low of $15,000 and a high of $200,000. But the maximum for individuals is $1 million, but it's $10 million for other persons. Other persons really means any non-individual, like an incorporated charity or even an unincorporated charity. So very significant potential liabilities. The private right of action is a proposed now still remedy for private individuals to bring actions essentially looking for the same type of remedy as the regulatory penalties, but which would flow to the individuals. And realistically, and there's been a lot of analysis of this over the last year, it's really understood, given the costs of bringing one of these actions, even though the potential remedy or amount is quite significant, it could be $1 million a day, but the cost of bringing that action is likely going to resolve to very well funded parties, which really means class actions. So we were looking at the potential of class actions, and it's against any organization subject to CASL, which obviously includes charities and not-for-profits. What I want to emphasize, and really where I want to end the discussion of compliance requirements, is I want to talk about compliance programs. And as you'll see, the last item on this slide, and it also was the last item on the last slide, notes that what is called a due diligence defense applies to both the regulatory penalties and the private right of action. And a due diligence defense is really what it sounds like. It's an organization exercising due diligence to ensure that they are in compliance with the Act. And if an organization has done that through various steps, and the key vehicle for that in my advice is what we call a compliance program. And that's not just it could be just a global program, but it is actually documented and reduced into some documents and procedures and activities. And the key document is as I've indicated in this slide, what I call a CASL compliance policy. And in the next slide, I won't go through it in detail, but I itemize what should be contained in that policy. Many of you may have that already. It requires record keeping. And again, I've got a couple of slides that articulate what is required for record keeping to show that you have, that all of the documentation that's required related to which includes consents, which includes who you mail to, are on record. It requires a training program to ensure your staff is aware of CASL and the requirements and ensure that they comply with those requirements. It requires auditing and monitoring, a complaint handling system, and ultimately and finally corrective action. So that's the best way, just the message I'm communicating in the context of the risks that are still existing for CASL and which I'm saying are going to increase on July 1st, very importantly because of the loss of the transition period, but also because of this sort of ending of the what we would call sort of run-in time, test out time, which the CRTC I think has looked at it as. And I refer you very importantly to that bulletin that's at the bottom of this slide. And just going over a couple of slides, this is the checklist for the compliance policy. And then I've got 2 slides on record keeping. And so there's a second CRTC bulletin, again, at the bottom of this, which specifically talks about records of consent, which is very important. In fact, under the Act, the record, there is a statutory onus to keep records of consent. That's the second bullet on that slide. But really, both of these compliance documents make very clear that a compliance program, as articulated by really in these documents, that's why they're very useful, these bulletins, but also in these slides, is really the key vehicle to establishing and putting your organization in a place where you could defend, you can basically respond to any allegation of non-compliance. So I'm just going to flip through that last slide on records, which I'll let you can go back and look at it, and certainly I'm happy to respond to questions. And I've got a checklist here. I think I will leave this. I've spoken a lot of this as I've worked through the slides today. I guess what, in addition to specifically looking at your existing communications, particularly with reference to the transition period, the last half of these top 10 things to do is basically review various procedures. And once you've reviewed those, determine what corrective actions are needed as a result of that review. It's really an assessment and review. It could be called an audit. So Cindy, that's where I'm going to end up right now, and maybe we can turn to questions, then I have some final questions. So you have.
Well, first of all, David, thank you so much for all of that rich content that you shared with us. You really helped make it easier for us today. And also, thank you so much for being a good sport about these technical glitches we've been that have been popping up since this webinar started. Sure enough, the timing's great. I mean, our biggest webinar yet, right? So our first question is from Children's Hospital Aid Society, and they're asking, does CASL apply to a charitable organization that does not sell goods or services?
To answer that question is, my answer is likely yes. Even though the charity does not sell goods or services, there are other commercial activities that the charity enters into. It purchases supplies. It will communicate with certainly its suppliers, and really anything that it may. For example, it will lease space. And there are specific exemptions for all of these. They're sort of business. They could be an existing business relationship or another basis, but you can't say just because we do not sell goods or services, CASL doesn't apply to us.
Thanks, David. So our next question is from Natalia. She's asking, are requests for donations considered a commercial activity?
No, they're not. And in fact, I can be hopefully a little more useful in that, in that if you promote, or let's say request tickets, promote tickets to an event that is purely for fundraising purposes, even selling tickets to that event well, it would be a commercial activity. So, but it is exempt because of the fundraising exemption that I mentioned earlier. Now, maybe I should just elaborate. I would say fundraising per se. I'm sorry to just digress a little bit. I think fundraising in a pure make a donation, that is not a commercial activity. A pure fundraising. If it has any contractual relationship to it, long-term fundraising, that would be a fundraising. That would be a commercial activity. So enter into some contract. That would be a fundraising activity. However, it's exempt under the exemption rule. And more importantly, I think this is important for many organizations, is selling tickets, selling products. If all of the proceeds from whatever you're selling goes to raising funds for the organization, that is considered to be exempt under the fundraising exemption.
Thanks, David. Doreen asked a great question here. Would we need to get express consent from the donors every 2 years?
No, I don't think so. Although express consent is a very helpful item to have to achieve, because once you've got express consent, you don't need to worry if you have not communicated with them in the last 2 years. So really the answer is if they continue to give, if it sounds like you mean this is an ongoing donor who just, let's say, gives annually, well, that will always qualify for the under the implied consent rule, because it will always be within the 2 years. If they hadn't given, if they gave 3 years ago, you would require express consent. So that's the reason for getting express consent if you can.
Got it. Okay. And Scott is asking a question that I'm sure is on a lot of our minds. So he's asking, we've been sending regular newsletters to our mailing list that have an unsubscribe option. If they haven't unsubscribed, does that qualify as consent?
No, I'm sorry to advise, it does not. In a simple term, and that's often asked, that alone does not constitute a consent under any category. Express consent could be voluntarily given to you just at the initiative of the individual without you even asking, and that is totally satisfactory. But if you ask for express consent, if you want to establish the express consent, you have to actually follow a particular form stipulated by the statute, which is really telling what you're asking the consent for, giving some contact information, and advising that they can withdraw it at any time. I should say one of the benefits of express consent is until withdrawn, it is permanent. So it doesn't have a time frame on it or anything. And just to sort of address from the implied consent rule, again, that the unsubscribe, not unsubscribing does not establish implied consent. But still, you're communicating with these people. And this is really one reason why you need to sort of delve into that database, whichever database it is, and look and see, well, there may be a lot of other reasons that we in fact do have implied consent, and that's what, going back to the top 10 things, is reviewing the categories of communications and figuring out what are the bases that make them comply, and where they, categories that don't comply, then address that issue.
Okay, our next question is from Deborah. Can you please give an example of corrective action?
Well, it could be a wide scope, but I mean, simple would be not having a fully compliant unsubscribe, which is and there have been cases on this involving for-profit organizations where they haven't had. An example was, I think, in one case, they didn't have a fully functional unsubscribe. They put all the information together, but it wasn't readily activated in a ready manner, and the organization actually ended up paying a penalty for that. So that would be ensuring the functionality of your unsubscribe, looking at the content of your unsubscribe, looking at your template that I mentioned, the CEM template, ensuring that it covers those key requirements that I've mentioned, and if it doesn't, make adjustments.
Our next question is from Shauna. If we are promoting a program that costs our organization money, where the money goes back into the organization, would that fall under the fundraising exemption?
Yes, I think broadly speaking it would. I'm going to give you an example. A dinner, which obviously costs an awards dinner that costs your organization money to put on, but all of the proceeds, and let's call it the net proceeds out of that, will go back to the organization as funds to the organization. That would be that would qualify as fundraising.
Okay, we have a ton of questions coming in, so we're going to get to as many of them as we can today. So our next question, does commercial purpose in an email include any of the following? A, fundraising event information, B, ticket information, C, ticket purchasing information, D, link to ticket purchase, and E, sponsorship opportunity information.
So as I mentioned in a couple of other responses, ticket information, fundraising event information, all would constitute fundraising for the organization. But if as long as they don't include, as long as these emails don't include any other commercial activity, and a commercial activity could be a sponsorship opportunity information, that would constitute, putting that in an email would then, and of course there's always the issue, what is the primary purpose of the email? But the CRTC has given some examples where a significant portion of an email contains sponsorship information. And they would say, well, if that's the prominent purpose of the email, then it doesn't constitute fundraising. Wouldn't qualify under the exemption.
Got it. Okay. So Brendan says, hi, David. I work for a Students Association, which is a registered charity and a membership organization. My question is, if we receive a membership list from the university, is express consent needed to contact our members the first time? Can we communicate with them after July 1st with a non-CEM email? Thanks, Brendan.
Which is a registered charity and a membership. Well, you can't be both. That's really the way that implied consent rule applies. It's just a membership organization is under the Act is not a charity. And as I read that rule, membership alone, which is you're now getting the names of the members, I don't believe that qualifies for the implied consent rule. The implied consent rule is quite specific. It is a donation or gift made to the organization, or volunteer work or attendance at a meeting. So if you'd like, I could certainly, if you have some further questions, and I was going to mention this, Cindy, we've talked about this, that I have my contact information is, maybe it's a good time to mention it, contact information I've just put up on the last slide. I am happy to respond to any further questions that that we don't get to today. I'll try to do it within a couple of days. I know this is very urgent, but you know, we've got a time dictated schedule here for July 1st. But certainly, if you have any follow-up questions, and if you'd like to, you know, ask me a further aspect of that question, I'd be happy to look at it.
Perfect. And we have a few more minutes. David, do you have time to take maybe one or two more questions? Okay. So our next question is from Darla. We are a private high school. We sell tickets to gala events, alumni, golf tournaments, reunions, etc. How does this law apply to our alumni and past parents of the school? Is it understood that there is an existing business relationship?
So I guess the question, I'm assuming the school is a charity, so you'd certainly look at what we call the existing non-business relationship categories of gift or volunteer work. But more importantly, if you sell items and services to the alumni, as you're suggesting, any commercial transaction, and as I mentioned earlier, it can be as simple as a ticket to an event that qualifies that would qualify for the existing business relationship category.
Okay, great. Why don't we take this question here? So somebody wrote in and wrote, I'm not clear on something to do with CASL or if this is changing for July 1st. If someone donates to my organization or gives us an email address through a form, for example, ordering a meal, and now we have their email address on file, is this enough consent to then send appeal letters, newsletters, etc.?
Sort of broadly, the answer is this is not changing on July 1st. If donating, as I've mentioned, qualifies as a non-business, non-existing non-business relationship, ordering a meal so really you indicate giving you an email address through a form, but the form is a form for you give the example ordering a meal. Well, that is a business transaction, so it would qualify under the existing business relationship rule.
I think we have time for just one more question. So Meredith wrote in and she wrote, I work for an association that is transitioning our membership renewal process from paper letters to email. Would these be covered under implied consent or would we need express consent?
It's both, really. The existing mailing list, the hard copy mailing list, per se doesn't qualify as either express consent or implied consent. Express consent, unless that has actually been stipulated by the hard copy communications you've had earlier. The implied consent would be that just the existence of the mailing list does not qualify as implied consent. You need to look at, under implied consent, I direct you again to those two broad categories: existing business relationship and existing non-business relationship. And the difficulty with those, I pointed out, but I can't emphasize it too much, is they're time limited. They're specific to transactions. The transactions may be very, very small, innocuous, as I pointed out, a meal, a ticket, whatever, but they're time limited. And so that's the problem is, well, when did that last happen? That's how you qualify. And so really sort of answering really no says you either have to go through that whole process of determining where implied consent can apply, or reach out and get express consent. And you may have this is the benefit of basically the remaining 3 weeks before July 1st, that you may have much broader scope. Presumably, there's been some relationship in the past. They're on your mailing list for some reason, and the two-year period doesn't apply. So reach out and get express consent if you can.
Okay, David. Well, thank you so much for answering all of these questions today. So as you heard David say, you have a few weeks to get up to speed. We hope you enjoyed our webinar today. Just a reminder that we will be sharing the recording with everybody. So if you missed a part of it earlier today, or if you want to share this recording with some of your colleagues or people you know might benefit, you can definitely do so. David kindly shared his email address for any questions that we didn't get to. So please feel free to shoot him an email, and he'll try to get back to you quickly. David, I'll pass it on to you to share any final words with the audience that you might have.
Thank you, Cindy. You're very welcome. It was my pleasure, and it's as I've alluded to, it's extremely timely, both in terms of developing events, which as of yesterday we've learned, and really more importantly, this transition period which is coming to an end. So refocuses the need. I've got several slides which I refer you to on the need for a compliance program and a checklist of what really should be done in connection with that. And leave you with that. Good luck, and all the best.